Welcome to Kenyan Constitutional Law 2, the people's sovereignty and the battle for constitutionalism. We begin our journey into the legal foundations that govern the Republic of Kenya. Over the next few minutes, we will master 4 core themes. First, theory and types of constitutions. Second, principles of legitimacy and constituent power. Third, the history of hyper-amendments. And finally, the modern amendment mechanics and institutional checks. To start, let's distinguish between 2 key concepts. Constitution making is the narrow event of drafting and adopting a new document. Constitution building, however, is the expansive, long-term process. This process includes establishing procedures, political reconciliation, and critically, the final implementation stage. Constitutions are categorized by form as written, codified, like Kenya's, or unwritten, evolved, like the UK's. By adaptability, they are rigid, requiring special procedures, or flexible, changed easily by ordinary law. By effectivity, a document is normative if it binds rulers, or merely nominal if it's ignored in practice. Moving to structure, vertical power is split between unitary, federal, and the devolved model, which Kenya adopted. Horizontal power gives us presidential, separation of powers, or parliamentary, fusion of powers. Documents are also classified by purpose, transformative versus preservative, and origin, autochthonous versus allochthonous. Legitimacy I, a constitution's endurance rests on legitimacy. This is multidimensional: legal legitimacy, conforming to rules, political legitimacy, national ownership, moral legitimacy, reflecting shared values, and sociological legitimacy, public acceptance. Constituent power, the power to replace a constitution, is the primary constituent power, the ultimate mark of the people's sovereignty. Parliament only holds secondary power, limited to altering the existing framework. This was affirmed in the Njoya case, 2004, ruling that Parliament has no power to abrogate the supreme law. Rigidity and flexibility, constitutional design seeks a vital balance between stability, which prevents erosion of the document's essence, and flexibility, which accommodates change. As noted in the AGV-DI case, Kenya aimed to avoid both hyper-amendments and ultra-rigidity. Finally, the debate on initiating change. Arguments for constitutional renewal include protecting minority interests and establishing clear fundamentals. Arguments against point to the high expense, risk of divisiveness, and the danger of constitutional principles being held hostage by the elite. We now transition to Section 2, Models of Constitutional Change, focusing on the historical paths that led to the 2010 framework. Constitutional replacement occurs through 3 main paths: the ex nihilo model, which disregards existing law, the nation-state building model for a newly founded state, and the transition model, where the existing document sets the legal rules for its own replacement, Kenya's choice. Judicial review, the crucial institutional check is judicial review. This is the court's power to uphold constitutional supremacy by checking inconsistent government actions. The power was asserted in Marbury v. Madison, establishing the court's duty to say what the law is. Basic structure doctrine, this review power leads to the basic structure doctrine. It holds that certain core features are fundamentally unamendable. This doctrine was confirmed in AGV-DI, BBI, where the Supreme Court confirmed that dismemberment requires the full exercise of the primary constituent power and a referendum. This brings us to Section 3, the historical dialectic, the direct consequences of colonial imposition to imperial presidency. Origins: the 1963 Lancaster House Constitution was an allochthonous document, imposed externally. It established Majimbo and a limited Bill of Rights, but was flawed by vesting excessive power in the Governor-General, laying the ground for executive abuse. Hyper-amendments, this led to the era of hyper-amendments. Over 33 amendments occurred, systematically dismantling the checks. This period saw the abolition of the Senate and Majimbo, the removal of security of tenure for judges, and the creation of the de jure one-party state. Reform: the reform movement began with the repeal of Section 2A in 1991. The political demand shifted towards an autochthonous, people-driven transition model, culminating in the COE and the mandatory referendum for the 2010 text. We conclude with Section 4, Constitutional Change Mechanisms, focusing on how the 2010 document secured itself against the past. The amendment routes. The 2010 Constitution has two formal amendment routes: parliamentary initiative, requiring a two-thirds supermajority in both houses, or the popular initiative, requiring 1 million voters and county assemblies' approval. Tiered system. The key defense is the tiered amendment system, Art. 255. Any changes to core features, including the Bill of Rights and judiciary independence, must be approved by a mandatory referendum, ensuring the people have the final say. The entrenched matters. The specific matters protected include the supremacy of the Constitution, the Bill of Rights, the presidential term of office, the independence of the judiciary and commissions, and the structure of devolution itself. Commissions. The constitutional commissions act as the integrity branch, a direct antidote to the imperial presidency. Their independence is protected by law and guaranteed by requiring a referendum for any attempt to weaken their function or structure. Practice. Commitment to constitutionalism provides clarity, stability, protection of minority rights, and clear lines of accountability via judicial review. The autochthonous process enhances political legitimacy and national ownership. In conclusion, the 2010 Constitution is a transformative charter built on popular sovereignty and a defense mechanism against history. The ongoing task of upholding the Constitution relies entirely on vigilance against political overreach. CTA, thank you for engaging. Please like, subscribe, comment below.